Article 1197. If the obligation does not fix a period, but from its nature and the circumstances, it can be inferred that a period was intended, the courts may fix the duration thereof. These provisions answers the question when can the court fix the period. Article 1197 provides for two grounds. Number one, if the obligation does not fix a period but if it can infer that a period was intended. Number two, when the duration depends upon the will of the debtor, the courts may not fix the period when no term was intended, if it is payable on demand and when it is specified by law. Article 1198. The debtor shall lose every right to make the period when after the obligation has been contracted, when he does not furnish to the creditor the guarantee or securities which he has promised. Number 3. When his own act he has impaired said guarantees and securities after their establishment and when through fortuitous event. Number 4. When the debtor violates any undertaking in consideration of which the creditor agreed to the period. Number 5. When the debtor attempts to abscond. This means that after he became indebted to creditor, if it is found that he is now insolvent, that means the debts are more than his assets. Because he is now insolvent, the creditor can now demand the debtor to pay his debt even before the arrival of his period. When after the obligation has been contracted, he becomes insolvent unless he guarantee or security for the debt. Article 1199. A person alternatively bound by different prestations shall completely perform one of them. The creditor cannot be compelled to receive part of one and part of the other undertaking. These provisions talks about the alternative obligations. Alternative obligation is when several objects or prestation are due but the payment or performance of one of them would be sufficient, which means out of these two or more prestations that can be give the delivery of one sufficient to extinguish the obligation. Article 1200. The right of choice belongs to the debtor unless it has been expressly granted to the creditor. The debtor shall have no right to choose those prestations which are impossible, unlawful, or which could not have been of the obligation. These provisions answer the question who has the right of choice. Alternative obligations. Out of these two or more prestations, there is only one should be given, and it will be satisfy the obligations. It says the right of choice belongs to the debtor unless it has expressly granted to the creditor. In general rule, the debtor will decide, but if could be the creditor if he will be the one to decide of what he should give to the debtor. Article 1201. The choice shall produce no effect except from the times it has been communicated. This means that the choice have no effect unless it has not already communicated to the party. Unless you don't have give the notice of what they choose a prestation and alternative obligation. The effect of notice until the choice is made and communicated, the obligation remains alternative. If proof and form of notice, the law does not require any particular from regarding the giving of notice, which may be orally or writing expressly or implied. Article 1202. The debtor shall lose the right of choice when among the prestation whereby he is alternatively bound, only one is practicable. This article answers the question when the debtor loses the right of choice and what is the effect when only one prestation is practicable. If only one prestation is practicable, the obligation is converted into a simple one. Article 1203. If through the creditor's acts, the debtor cannot make a choice according to the term of the obligation, the latter may rescind the contract with damages. The rescission creates the obligation to return to which were object of the contract together with their fruits and price of its interest. It is very nature of an alternative obligation that the debtor can make his choice without the consent of the creditor. Hence, the right given the debtor to rescind the contract and recover damages if through the creditor's fault he cannot make a choice according to the terms of obligation. Article 1202. The creditor shall have a right to indemnify for damages when, through the fault of the debtor, all the things which are alternatively the object of the obligation have been lost, as the compliance of the obligation has become impossible. The indemnity shall be fixed, taking as a basis the value of the loss, this which disappeared, or that of the which loss became impossible. These provisions talks about the effect if one or more all of the things the debtor promised to deliver got lost. It provides for more alternative rights of creditor when lost on impossibility course before the debtor's choice. The right to choose belong the debtors and the loss or impossibility happened before selection was made. Article 1205. When the choice has been expressly given to the creditor, the obligation shall cease to be alternative from the day when the selection has been communicated to the debtor. The same rules shall be applied to obligations to do or not to do in cease of one sum or all of the prestations shall become impossible. These provisions talks about the responsibility of debtor to damages depends if it was due to his fault or not. Rules are only applicable to personal obligations if creditor failed with his right to choose. There is no delay on the part of debtor even there is definite period fixed for the performance of obligation. Default or delay or the debtor arises only if when obligation becomes simple won by the exercise of creditor of his right to choose. Article 1206. When only one prestation has been agreed upon, but the obligor may render another of substitutions, the obligation is called facultative. The loss or deterioration of the thing intended as a substitute through the negligence of the obligor does not render him liable. But once the substitution has been made, the obligor is liable for the loss of the substitute on account of his delay, negligence, or fraud. These provisions defines what is facultative obligation. It says that only prestation has been agreed upon, but the obligor may render another substitution. The effect of loss before substitution is the principal thing is lost through the fortuitous event. The obligation is extinguished, either the debtor is liable for damages. The effect of loss merely to extinguish the facultative character of the obligation.